Good morning, and thank you for joining us for today's webinar, Dealing with Virtual Court Hearings. We're very grateful that you've taken the time out of your day to listen to today's webinar. I'm going to talk about the key steps in litigation up to managing a hearing remotely. I think there'll be something for everyone with some general guidance and tips as we go along, so hopefully it will be of use. Now, before I start, just some housekeeping, first of all. Thank you very much for those who've already submitted questions. If you'd like to ask questions throughout this webinar, please feel free to do so. If you can use the Q&A function on your screen, it should be on the bottom right of your screen. I'll endeavour to answer as many questions as I can towards the end of the webinar. Now, we will be recording this virtual event, and it will be circulated after the webinar is finished. So please feel free to listen in if you've missed anything or to forward on if needs be. Now, you can send questions through after the event as well to our email address, events@irwinmitchell.com, and I will be repeating that email address at the end as well. Okay, and then finally, we are hosting a number of weekly events at Irwin Mitchell. We'd love to hear from you with some suggestions as to what you might like to hear from us about, so please feel free to get in touch. We would love to hear from you. So, dealing with virtual court hearings. Before I go into the substance of the hearing, just a little bit about me. I am Richard Biggs, a Senior Associate Solicitor based at Irwin Mitchell in our Manchester office. I specialise in catastrophic personal injury cases, which covers amputation cases, spinal cord injury, brain injury cases, and although my background is in personal injury, today's webinar is going to cover all aspects of civil litigation, so I hope there will be something for all of those who deal with any aspects of civil litigation, and anybody who may be involved in dealing with court hearings, and also who's facing the challenge of dealing with a court hearing remotely during the present pandemic. So what we're going to cover today? Well, as I say, it's the managing key steps in the litigation. First of all, we'll look at drafting and e-signing of witness statements. That will actually cover all documents, or most documents that we will need to complete and send to the court and to exchange with our opponent in the litigation. Similarly, filing and serving documents electronically, which is a particular challenge at the moment in present lockdown. I'll explain some ways around that. Then we'll talk about preparing for a virtual court hearing. And then finally, conduct of the hearing itself and some practical tips to help you ensure that the hearing goes as smoothly as possible. So we'll start with drafting and signing of witness statements. Well, it's a challenge anyway to prepare and draft a statement remotely. Normally it's done face-to-face. But just to add a little complication as well, there was a rule change on the 6th of April 2020, which revised the Statement of Truth. Statement of Truth is the declaration at the end of a court document, a witness statement, or whatever that might be. And the Statement of Truth used to say, pre-6th of April, I believe that the facts stated in this, and whatever document it is, are true. That was changed as of the 6th of April, and it now reads, I understand that proceedings for contempt of court may be brought against anyone who makes or causes to be made a false statement on a document verified by a statement of truth without an honest belief in its truth. Well, why is that relevant? Well, because from the 6th of April 2020, there was a further practice direction issued, which further changed the rules. And what that direction said is that the process and circumstances must be set out when the statement was taken. So that means in the present pandemic, when we're not taking statements face-to-face, process and circumstance need to be covered. So what it means practically is when you're preparing or when you're giving a statement or any documents which will be used in the court, process and circumstance must be covered, i.e. this witness statement or whatever document it may be was given over the telephone, and circumstances, well, I typically use something along the lines of this statement was given over the telephone at a time when government guidance cautioned against face-to-face meetings. And that covered the process and circumstance, but it's an important amendment to the rules and important to bear it in mind when you are drafting or giving any statements or other documents to the court. And I said, who signs a statement? Well, it might be very tempting in the present pandemic to sign a statement now on behalf of a client or on behalf of somebody else. I've said litigator beware, because coming back to this rule change that I said at the outset of the slide, the revised statements of truth, and remember the words, proceedings for contempt of court may be brought against anyone who makes or causes to be made a false statement. So if somebody or if you sign a statement of truth on behalf of somebody else, beware of that rule change, and the potential proceedings for contempt of court may be brought. My view is it should always be signed by the person giving the statement, and you should be very cautious indeed about signing on behalf of somebody else. Now, e-signing of documents. This applies to not only witness statements, but to any other court documents. So how do we get documents signed? Well, previously the easiest way, when we can't do it face-to-face, would be to send it via email. It can be printed, scanned and returned. But I'm finding not everybody has a scanner. It can be problematic. So how do we get around this, and how do we get documents signed? Well, documents can be e-signed. I'll come on to explain how, but first of all, are e-signed witness statements, are e-signed documents valid? I've not been able to find any recent court authorities on this, actually. But I've trawled back a few years and found one case where an e-signature was held to be valid. There's nothing recently, but my view is that, yes, e-signatures are going to be valid. And I'll come on to this later in the presentation, that the court is going to be inundated, I think, in the next 6 to 12 months with potential satellite litigation, or litigation where people have sought to take advantage of the present pandemic. And I'll explain later in the presentation that I think courts are really going to take a dim view of anybody who tries to take advantage of the current situation. And that will go along really with the validity of e-statements, of e-signing, because I cannot see that a court would be critical of somebody e-signing a document where face-to-face meetings are currently advised or cautioned against by the government. Now, how do we do this? Well, we've been using a quite simple app, Adobe Read and Sign, or Adobe Pro, free to download, very simple to use. It's an app which can be used to e-sign a document, and then it can be emailed back to whoever sends it to you. So that's a really straightforward way of getting a document e-signed. But remember again to reflect this in the witness statement. So going back to what I said, process and circumstance of the statement, or process and circumstance of any document, remember that it should say it was taken over the phone at a time when government guidance cautioned against face-to-face contact, because that will explain and will give justifications to why an e-signature was necessary. And I think with that justification and that transparency really that we need, I think an e-signature is going to be valid and accepted by the court. Filing and serving documents. Now, this is a challenge, particularly where courts are closed at the moment. All offices are closed. It's difficult to file documents. And particularly, there's a rule, civil procedure rules, which govern the way that civil litigation is run. Practice Direction 6A 4.12b, that says that service can take place by email, but only by prior agreement. So don't assume, if you're going to send a document to somebody, don't assume it can be done by email unless you have their prior agreement. Now, it's a matter of good practice on every case that we run, and every case that you may be involved in, to seek that prior agreement from whoever you wish to serve documents on, to say, we want to serve documents by email. Will you accept service by email? Similarly, I would, in exchange, say, we will also accept service by email as well, but only on a case-by-case basis. And what I mean by that is, don't give a carte blanche agreement on everything you do to say, we will suddenly accept service by email, and expose your company to potential service by email for an indefinite period of time. So case-by-case basis on each case, we will accept service by email and ask for like agreements from whomever you're serving the documents upon. Now, finally, remember to password protect. I know we're probably all fed up with GDPR over the last couple of years, but it's more important than ever at the moment. So documents must be password protected, especially confidential court documents. Passwords should follow in a separate email or call or text, but it's absolutely crucial in the present climate. We don't want to fall foul of GDPR as well. Okay, now, completing court documents. This has been a challenge because traditionally we've used laser forms at Irwin Mitchell, but they can't be e-signed, was found. So the way to do this and the way to fill in a court document to then serve and sign it is to save it to a PDF. So complete it, save it to a PDF, and it can then be e-signed. But one difficulty we've come up against, actually, and one of my colleagues flagged this up, is in the Royal Courts of Justice in London, we found that documents that were then filed as a PDF format couldn't actually be read by the court. Now, there's a simple workaround for this. I've said on the slide, convert the PDF to a non-editable version first. Once that's done, it can be filed and the court can read it. So a really simple workaround. And finally, just going back to this rule change on the 6th of April, remember the revised statements of truth, and remember that the documents you serve must have the correct and up-to-date statements of truth signed. So remember to use up-to-date documents. Collaboration. This is going to really be a theme running throughout this webinar, and I'm going to mention this over the next couple of slides in particular. Collaboration is absolutely key at the moment between all parties. There's an APL and FOIL best practice document. What that means, APL is the Association of Personal Injury Litigators, and FOIL is the Forum of Insurance Lawyers. There are the industry bodies who represent personal injury lawyers and insurers. There's a best practice document that has been reached between the two, and it talks about a limitation amnesty agreement, which is a time limit for bringing claims. I mention it here simply because it's an example, a good example of collaboration in litigation. And collaboration is going to be more important than ever now. Now, there's a new practice direction. We keep being given these new rules in the present lockdown. Very helpful practice direction under the civil procedure rules called 51ZA. It applied from the 2nd of April 2020. It's valid until the end of October 2020 for the time being. It may be extended, we don't know. But what it says is that in the rules, generally the parties can agree to vary a timetable given by a court by 28 days without seeking court approval. So, i.e., if there's a date, for example, for exchange of witness statements or of any other documents in the litigation, the parties can generally, between themselves and without asking the court for any permission, agree to vary this by 28 days and give themselves another 28 days, which is going to be very important in the present challenging climate. The rules, however, have now changed to allow us to vary the timetable by 56 days, so nearly 2 months to vary a timetable, which is very helpful indeed, and one which I've already seen working in practice. It comes back to that key point at the bottom of the slide. Collaboration is absolutely key. Collaboration between the parties, help the court system, don't go to court unnecessarily, and where there's a reasonable request made by somebody in the litigation, it should be agreed in my view. Continuing with collaboration and continuing really with practice direction 51ZA. Now what this said is that insofar as compatible with the proper administration of justice, courts will take into account the impact of the COVID-19 pandemic when considering applications, and these are such as extension of time for compliance with a timetable, adjournment of hearings, and applications for relief from sanctions. Opportunists beware, because I think when all of this is over, when we're all back in our offices and back at court, I think there'll be a number of applications, a number of key aspects of satellite litigation brought because people have unreasonably refused the request to collaborate, to agree to an extension of time, have sought to be opportunistic and to take advantage of the present situation, I think the courts will take a very dim view. And the courts are telling us that, are giving us notice that this may well happen because the court will take into account the impact of the COVID-19 pandemic. The rules are there. The rules are there for the courts to use. In 6 to 12 months, do not be the person trying to justify for a district judge as to why you try to take advantage of the present pandemic, i.e. beware of seeking unnecessary advantage. Collaborate where possible. So it's business as usual. The courts are still trying to run hearings as much as they can. So when preparing for a court hearing, don't assume it will be adjourned. Prepare as you would for the court hearing to take place in person. Don't assume that it might not take place because you might get a nasty surprise. Things are taking a bit longer to prepare for. The courts are understandably inundated with emails and with trying to deal with hearings remotely. So leave yourself plenty of time to consent. If there is going to be agreement between the parties, then make sure you reach that agreement in plenty of time before a court hearing, and make sure you let the court know in plenty of time that there's been agreement between the parties, whether that's agreement to part of what the hearing is about or whether it's all of it. Leave yourself plenty of time, because not only will it take longer to prepare, because we're all having to access, or most of us are having to work without documents in front of us and without paper documents, but it's going to take longer to prepare for court hearings. It's going to take longer to get documents signed and served. So give yourself plenty of time and make sure good time management is at the top of the agenda, because if there is agreement, then you should notify the court in plenty of time. Now, preparing for your hearing. So we've got the hearing coming up in your diary. How do we prepare and what do we do? Well, in Manchester, actually, where we do a lot of our work in the High Court, the designated civil judge for Manchester, who's called His Honour Judge Bird QC, recently gave guidance to all parties involved in litigation, and he gave an order which has now been reflected by all the judiciary in Manchester, and it's been rolled out. It's been replicated in hearings across the country, and I've called it the COVID-19 order. What a COVID-19 order is a very prescriptive order from the court which sets out exactly how the hearing should be run. Now, it will say that the hearing is going to be virtual, it's going to be by telephone, or it's going to be by video link. It will then be very prescriptive in telling the parties exactly what we need to do. Now, the wording in some of the orders that I've seen says the court expects the utmost cooperation between the parties. So the court isn't inviting parties to cooperate, the court is ordering parties to cooperate and collaborate. And I've called it here in the slide the 3 C's, just to keep these 3 C's in mind in preparing for a hearing and preparing in looking at your COVID-19 order, looking at what to do to make sure you're ready. But the 3 C's are cooperate. So again, cooperate with your opponent. More time if you need more time, if it's reasonable and in your client's best interest, of course. Provide them with documents if they're unable to access documents themselves. If there's agreement between the parties, consent. Consent whether that's part of the aspects of the hearing under dispute or whether it's all of it, but consent and let the court know. Or cost order. There could be a cost order. So what I mean by that is that if you unreasonably refuse any request under one of these orders, if you don't collaborate, cooperate, consent, you could face cost order against you, and the judges may find that they're having to punish those parties who aren't willing to enter into the spirit of this utmost cooperation that the judge has ordered in that COVID-19 order. So just a final word on that order. Look very closely at your order and make sure you comply with it. And just a little bit more about the contents of that order itself. I said perhaps, do you really need that hearing? Well, we're going to work in a very different way, I think, when all of this is over. And I'll come on to explain why I think that's the case. But when you've got an order, when you've got the hearing ready, have a think. Do you really need that hearing? Does it have to be in person, first of all, because it may need to be adjourned, and we'll come on to that. Alternatively, do you really need the hearing to take place at all? Because if that's the case, if you're adamant that the hearing doesn't need to go ahead and it can be agreed by consent, then I think we're all under a duty to help the court system to really ensure that the courts aren't overwhelmed by the number of remote hearings they have to deal with. So if an application can be made on paper, then that's acceptable, provided, of course, it's in your client's best interest and in the best interest of all involved. If it can be, agreed by consent, then great, that should be done as well. But think very carefully, focus before the hearing. Should it take place? How should it take place? And how best are we going to achieve the best result for our client, but also how are we going to help the court system? Now, moving on, the e-bundle. So we have the hearing ready. We have it in our diary. We know it's going ahead. How do we prepare, and how do we get the e-bundles to the court and to our opponents? Well, again, read the order very carefully to see what the e-bundle needs to contain. It isn't going to be like the old days, I say the old days pre-lockdown, where bundles of documents were lever arch file after lever arch file. I had a hearing before the High Court in November where there were 20 lever arch files before the court. Just not going to happen anymore. It's completely unrealistic for massive bundles to be sent electronically to the court. So have a think about what you need to contain and what you need the bundles to contain, rather, and what you need the judge to really think about and to advise upon at that hearing, because it should be succinct and it should be focused. I'll come on to this again in the next slide, but really I think it's going to help us work in a different and possibly better way, because we're going to have to really focus our minds on thinking, what is the key to this hearing? What does the judge need to know about? What is the judge being asked to rule upon or decide? And are the documents within the e-bundle sufficient for the judge to be able to reach a balanced and fair decision? The orders that were given generally say we need about 3 days notice, or the courts require 3 days for the bundles to be filed. I think it's at least 3 days, really. It should be before then, because we found that email and e-bundle sent to a central filing email address is all well and good, but when the courts are operating on skeleton staff and where they're receiving huge amounts of bundles regularly ahead of hearings, it can be overwhelming for court staff. So give the court plenty of notice, more than 3 days where possible, so file your bundles in plenty of time. And as I say on this slide, I think it's goodbye to lengthy bundles. I think this is a new way of working for us all, and I think it may well continue when we're back in the office and back in court. Just continuing to discuss e-bundles, there will be an order, the COVID-19 order, which will tell you about what the e-bundle is expected to contain. Now, as with documents filed with the court, attachments should be no more than 10 megabytes, so make sure you comply with that, or your bundle might not be received at all. The orders frequently say a maximum of 100 pages where possible. Now, when you're filing a bundle which may have a medical report or some other document which is 40 or 50 pages long, it's completely impractical to expect everything to go in the bundle and expect it to reach the 100 or not exceed the 100-page limit. It just won't happen. So my view is that extracts of documents are perfectly acceptable. So taking the example of a medical report, if it's 40 or 50 pages, why not just include an opinion and a prognosis or a summary of the assessment if that's required? Of course, it has to be what's reasonable for the judge to consider, but I don't think, using the example of a medical report, you need to include pages and pages of reviews of records or other medical reports if they're not absolutely necessary, the purpose of that hearing, because we need to be focused, as I said in the earlier slides. We need to make sure that we comply with the order, and we need to make sure that the hearing goes as smoothly as possible. And we have a duty to the courts and to our opponents to collaborate and to make sure we are succinct as possible. And the orders often require a reading list for the judge. Well, if there's a reading list, and there should be, and I think it's a great idea, then be realistic, because there's no point saying to a judge that he or she needs to read 100 pages of documents if the judge has only allowed themselves 15 minutes reading time. So be focused, be realistic as to what the judge might need to read. Continuing with formalities of e-bundles for all those who need to file e-bundles ahead of a hearing. Well, they need to be in PDF format, so make sure you comply with that before you file them. All documents must be in one single PDF file. They can't be split. Otherwise, the court may well take a dim view and the bundles might not reach the judge. So the documents in one PDF file, which must be searchable as well. So an e-bundle should be like a paper bundle. It should be capable of navigation by a judge. It should be easy to refer the judge and a witness or an opponent to a document within the e-bundle as you progress through the case. It should be paginated, so it should be numbered on the bottom right-hand side. Now, handwritten pagination isn't appropriate. It has to be computer-generated. There are plenty of apps and plenty of guidance online, actually, about how to paginate documents electronically. I'm not going to go into it in any more detail here, but pagination must be computer-generated, and each section and document should be separately bookmarked. So again, it should be capable of navigation. It should be easy for a judge to find documents as they would with a lever arch file in front of them. So we're preparing for the hearing. We have our e-bundles filed. We know that we're ready. We know the hearing is going ahead. So how is it going to work? Well, Practice Direction 51Y governs the use of audio and video hearings. Normally it will say the hearing is to take place by Skype. But if you find, or your client finds, that Skype isn't an appropriate format, isn't the right software for you, then there's no reason why you can't make representations to the court to ask for an alternative platform to be used. For example, in a recent hearing, the parties were more comfortable with Zoom rather than Skype, and the judge said that was perfectly acceptable. So the courts are being very flexible. The courts are willing to listen to the parties. Generally Skype, it doesn't have to be. We're seeing more telephone hearings and video hearings. Whatever you do, read the order carefully and make sure make sure you know the one you're preparing for. I can't think of anything worse than sitting there in your pajamas waiting for your telephone hearing to start before the video, the Skype flickers up and you realise actually it's a video hearing after all. So make sure you're prepared. And remember, you're in court as soon as the conference, as soon as the Skype, the Zoom, whatever is going to be, or the telephone call starts, you are in court. It's easy perhaps to forget this when we're sitting in our living rooms or kitchen and we're working in this very different way, but you're in court. If it's a video conference, it has to be business attire. Backdrop are absolutely key, so make sure there's nothing which can be distracting behind you. But always remember, and I'll come back to this, remember, you're in a courtroom, you're not in your lounge. Prepare accordingly. So let's look at some practical tips for the hearing, which is now to take place. So, leading up to the hearing. Well, first of all, I think it's good practice. Why not check with the court and with your opponents that they have the bundles, they have the right documents, they have the right bundle. Of course, the court might just set your mind at ease, really, as to what the court has. Test your setup. Don't wait until 2 or 3 minutes before the court hearing is about to start, before checking whether or not your Skype connection works, whether you've got the right hardware or software. test it the day before if needs be. And I'm going to touch only very briefly on the way a trial is run, and I'll explain in the next few slides as to why that's the case. But where there is a hearing which involves more than you and the judge, or more than just you and your opponents, perhaps, then think about separate lines of communication. One example I've given here is if it's you and a barrister, why not set up a WhatsApp communication that you test, of course, the day before, but a separate WhatsApp communication to have it, another device, your phone next to you, whilst you're conducting the hearing on your laptop, and have that communication so you can talk to your barrister and communicate or with your solicitor as well as needs be via WhatsApp as the hearing progresses. That is also the case if, for example, you're running a trial or a hearing where witnesses are involved, and you may need a second WhatsApp line of communication set up so you can communicate with witnesses or with another party before or during the hearing, not, of course, when they're giving evidence, but beforehand or after they're finished. So think about that separate line of communication very carefully. Make sure that they're very distinct, because you certainly don't want to make the mistake of sending a WhatsApp to the wrong group. Think about it, test it, make sure it's ready before the hearing. Now, be prepared. Be prepared for the worst. We know we had some teething troubles initially when we were running some of the remote hearings, which I'll mention over the coming slides. But be prepared, because you may lose your connection. And if that's the case, be ready, know what number you have to dial back in on. You may lose your advocate if you have a solicitor or barrister who's running the hearing for you. Be prepared that they may drop out of the call due to poor Wi-Fi or due to the way that Skype is working. If that's the case, if your advocate drops out, bring it to the attention of the judge immediately. A judge will not object to being interrupted if an advocate has dropped out of the hearing, and the hearing can then be paused before they can be brought back in. Now, be very conscious of your microphone. If you're not speaking during the hearing, mute it. Absolutely key. But beware that you can be heard at all times. So be very conscious of what you are saying. And as I say, mute, really, when you're not speaking. And just because you're at home doesn't mean you can't be seen. And don't forget you're in court. So whatever you do, don't pull faces, make gestures, act disappointed, sigh, react in any way, as you would in a court room. It's a poker face, expressionless. Don't assume because you're sitting in your lounge that the judge isn't watching you. So always bear that in mind, and remember that you're in court, and conduct yourself accordingly. How can we make it work? Well, in practice, I think we're getting better. Patience is absolutely paramount. And I say patience is paramount because it may take time to connect to the hearing. We've had hearings recently whereby it's taken a long time to connect, and we have to sit and patiently wait. Unfortunately, it's the same for us all, and we have to be aware that it isn't going to run perfectly smoothly as we would hope. Breaks are absolutely key, and if there's a hearing which lasts more than an hour, 2 or 3 hours, or it may last all day, and you have a 10-minute break, go in the garden for 10 minutes, walk around the house a little bit, because it's going to be a long hearing. It's going to be tiring and difficult to concentrate. So take the breaks when you can. I think it's important. We can't have drinks and snacks in a courtroom, but we need them at home. To have drinks and snacks ready for the hearing, again, it comes back to making sure your microphone is muted, because there'd be nothing worse than the sound of somebody eating. But just have them ready. Prepare for the long haul of the hearing, because, as I say, patience might be necessary, and it may take longer than it would if you were sat in a courtroom. Avoid interruptions and background noise. Make sure the kids are aware that you're in court. Make sure that nobody's going to come and interrupt you and come into the room you're in. Background noise, not only really from the house or wherever you are, but from outside as well. So where possible, if you can find a quiet room away from from the noises of outside. For example, you may have somebody mowing the lawn, and that can be incredibly distracting for you and for the judge. So whatever you do, avoid background noise at all. And just remember, it's going to be tiring. I'm sure everybody finds that working at home is incredibly tiring, and come the end of the working day, often we find we're exhausted. I know I do. A court hearing is tiring anyway, but a court hearing remotely and concentrating on a screen is very tiring indeed. So prepare yourself, and don't be disheartened or disappointed if you are very tired at the end of the hearing itself. It's perfectly normal to feel that way. How's it working? Well, there were some early teething troubles, but I do think it's getting better. I had in the first week of lockdown a baptism of fire, where I had 2 big court hearings involving multiple parties. In the first hearing, we found that although we filed a bundle in plenty of time, it hadn't reached the courts because the court was so overwhelmed with all of these e-bundles being filed electronically. So that, unfortunately, was adjourned. On the second hearing, we found that parties were dropping out of the court, and we found that the court, although had received some documents on this occasion, hadn't received others, so it was a bit hit and miss. And so there were those early teething troubles, but getting better. My experience recently is that people are collaborating and finding ways around working with remote hearings, and they're finding that there are good practices to work in filing documents electronically, and I think we're getting better. So I've said that the wheels of justice are continuing to turn. Trials are taking place. I read about a 5-week, very complex commercial trial which is going to take place over the coming months. I think the parties perhaps had assumed it might be adjourned. That's not the case. It's going ahead. So trials will take place. As I said earlier, it may not be the case that your hearing is adjourned. The courts are trying to deal with as much as they can remotely. I'm not going to go into detail here about how a trial is conducted remotely, because that would be an entirely separate webinar. But there's some great guidance online, actually. And I've picked one here on the slide. The 9 SJS is St John Street. It's the Barristers' Chambers in Manchester. And they've conducted a 25-minute hearing with 2 barristers, a judge and 2 witnesses, so a claimant and a defendant in a personal injury case. And they show over those 25 minutes how a witness is questioned and how a witness is cross-examined, how they interact with a judge. And I think that's a really useful snapshot as to the running of a remote trial. And finally, it's not bad news. I think we're learning new skills. I said earlier, I think we'll become all more efficient in the way that we work. We'll become more focused, perhaps, in the way we prepare bundles, more focused in the way that we really think about what the court needs to consider and rule upon at a hearing, and then consider what the documents a judge will need to enable he or she to make that decision. So I think we're learning new skills. I think we are going to benefit from this, at least in one way. Now, one size does not fit all. So I've talked about the way a hearing will be conducted remotely, and I've talked about how courts are continuing, hopefully, to run hearings remotely. Well, one size doesn't fit all, and it might not always be appropriate. But this case on the slide, Repeat a Child, is very recent. It's in the last week or two. And it's a family law case. The court adjourned the hearing. There's a discussion whether it should be held remotely. And there are all sorts of issues in that case as to why the mum of P couldn't attend the hearing remotely. There were lots of different practical issues as to why she wasn't able to attend. And the court held, I would hold that the hearing cannot be properly or fairly be conducted without mum's physical presence before a judge in a courtroom. So it doesn't mean that the hearing will always take place remotely. It can be adjourned if that's inappropriate, and I'll explain a little bit more when I answer some of the questions at the end. But where it's not appropriate, and the key terms in this quote at the bottom of the slide, where it cannot be properly or fairly conducted, it will be adjourned. So don't be disheartened if you think this hearing shouldn't be remote. It's not going to be fair. the court will be pragmatic in thinking about how the hearing should be run. But on to the future. So where are we going to be when all of this is over? I think there'll be a backlog in the courts, but where the courts have tried to hold as many hearings as possible remotely, there will still be a backlog. As we've seen in the earlier slide, there will be hearings that are going to be adjourned because they have to be face-to-face. There'll be hearings that are adjourned certainly in the early days because the court hasn't had all the documents that the court will need to see. So there will be a backlog. Litigation will be protracted where a case may last 3 or 4 years, perhaps, on average in some complex cases. We may find it lasts another 6 to 12 months beyond that because there may be a delay whilst we're waiting for a hearing to be listed. But similarly, there may be a delay as well because once we find the courts are reopening, the courts are going to have a significant backlog of cases to list, and cases which may take, or in the past taken 1 or 2 months to be listed, now could take 7 or 8 months because the court is trying to catch up with all the hearings which haven't taken place during the lockdown. And I said satellite litigation is inevitable. We touched upon that earlier, and we said, well, there may be people that are taking an opportunistic approach. There may be people who are trying to take advantage. If that's the case, there will be litigation before the courts. Courts are going to be pragmatic and sensible. So bear that in mind in how you deal with a case now, and collaboration, again, is the key. So finally, we're looking, I think, at a new way of working. I think this is going to be a change for us all, or has been a massive change for us all, but it's going to affect the way we work in future, I think. It's not all in doom and gloom. Judicial feedback has been positive. I've been keeping a very close eye, actually, on social media and judicial feedback, actually, on how hearings are being run. And the judicial feedback has generally been quite positive. So I've had a couple of comments in the last few days by district judges who have said, okay, remote hearings are not always ideal and not always the right fit for some cases. However, some case management hearings, some timetabling hearings can be done remotely. But in the future, I think we'll see more of these hearings done remotely where agreement is reached between the parties and where the court think it's sensible to do so. So I think there may be a more efficient way of working. I hope and expect that in the future, we may not be travelling long distances to go to court because we'll find it can be done remotely, provided it's fair on all parties to do so. So thank you very much. I hope that was of assistance. I've tried to cover quite a broad range of key steps in the litigation. I'm going to try and look at some questions now shortly. As I said earlier, if you have any questions after the webinar, please feel free to send them to this email address, and we'll respond to you with some questions after the event. We'd love to hear what you think about today's seminar as well, and we'd love to hear suggestions from you as to what you might like to hear from us about in the future. So I'm just going to look at some questions. Okay, I'm having difficulty looking at some of the questions, but some of the questions submitted in advance, we were asked about what happens where a court hearing might not fairly take place by laptop, so where it can't be done remotely. Well, I mentioned that one size doesn't fit all, and it may not be appropriate for a court hearing to take place remotely. Well, there was a case that I mentioned a couple of days ago, a couple of slides ago rather, but there was also Court of Appeal guidance that was issued yesterday, so hot off the press. And for those of you who are interested, there was a case called RE-B, Children Remote Hearing Interim Court Order. The citation for that court hearing, EWCA CIV 584. The Court of Appeal gave guidance about remote hearings. And as I say, it was a case handed down yesterday, very important case, and certainly for the person that kindly sent through the question asking about whether where you're expected to attend a hearing in person, whether you're expected to deal with it remotely where it might not be appropriate. What's the answer? Well, the Court of Appeal considered yesterday the dangers of remote hearings and the need to take considerable care when important decisions are being made. And I'll read from the judgment yesterday. And the court said, in the present abnormal circumstances, the fundamental principles of substantive law and procedural fairness are unchanged. The court went on to say, we must be alert to ensure that the dynamics and demands of the remote process do not impinge upon these fundamental principles. So finally, the court must therefore seek to ensure that it does not become overloaded and must make a hard-headed distinction between those decisions that must be prioritised and those that must unfortunately wait until proper time is available. So if you are being asked, if you are expected to attend a hearing remotely and you feel it's inappropriate, look at this case carefully. Look at ReBe Children, because the Court of Appeal has said, and I'll just choose those keywords again, procedural fairness must be priority. The fundamental principles of a hearing, fairness, access to justice, can't be affected by remote hearings. So absolutely key that those principles are followed. And the court is prepared to be pragmatic and the court is prepared to be sensible. So where you think that the hearing shouldn't take place remotely, representations need to be made by your legal representative to the court immediately to say this is not going to be a fair and realistic and reasonable hearing because it should be done in person. And that's perfectly acceptable. And then the second question, which we kindly received in advance, was about speaking or dealing with a witness remotely. I've touched upon that beforehand. Make sure you have that line of communication set up before any witness gives evidence. Test your system certainly the day before. Make sure that everybody can connect and can hear each other. Make sure it's working in practice. And remind your witness, as you would a witness who's attending a courtroom, this is a courtroom. This is going to be done this is not going to be done face-to-face, but this is going to be done in a virtual courtroom, and you should conduct yourself accordingly. Okay, thank you. I hope that helps. Finally, I'd just like to thank you all for joining us and connecting during these challenging times. I hope you found this webinar useful. I hope it was useful to cover as much as possible in the current climate. You'll see on your screens a screenshot of our website, and can I just explain that we're looking at running webinars weekly, so I mentioned that please feel free to send us your ideas to the email address we gave earlier. Please look at our website, and in particular, look at this section of our website, which covers all things legal and financial arising following the outbreak, and we're updating our website and this section of the website regularly. So please feel free to have a look at our website, and hopefully you'll find some information of use. So thanks again, everybody. Stay safe, and we hope to see you at some future webinars. Thank you.